All right, pause right here. This is where bond becomes the battlefield. A $300,000 bond for aggravated assault with a deadly weapon isn't just about punishment, it's about risk. The judge is weighing public safety, prior behavior, and whether this defendant can be trusted outside those jail walls. Question for you: should bond be about access to freedom or protection for the community?
Did you see the response? Yeah, it's been a little bit. It's been a while. Yeah, emotional. All right, so are you Jonah Johnson? And Mr. Johnson is charged in cause number 25 DCCR 1775 with aggravated assault with a deadly weapon. And Ms. Holmes has filed a motion asking that Mr. Johnson's bond be reduced. It's currently set at $300,000, and then there's also 2 misdemeanors that he has as well. And those bonds, it looks like $3,000 and $5,000, which we're not discussing, but just that he has charges also, in addition to aggravated assault with a deadly weapon, to misdemeanor charge of unlawful carrying a weapon, 2 cases of unlawful carrying a weapon. And so Mr. Coleman filed a response, obviously in opposition to that. Ms. Holmes, Mr. Johnson, best you can, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, thank you. You can put your hand down. You may proceed, Ms. Holmes.
Thank you. Johnson, how long have you been incarcerated on Jefferson County? Okay. And, the 2-month ban your bond has been...
This part matters more than people realize. Once a bond gets raised, especially after an alleged violation, judges get extremely cautious. The court isn't just looking at money anymore, it's looking at reliability. If you couldn't follow conditions once, why should the court believe you'll follow them again?
Is that correct? And has your family tried their best to cure or try to get you bonded out at that amount? Okay. Now, prior to this, was your bond originally at a different amount and was it raised at some point? Okay. And do you have any property or anything that you could possibly sell to secure what the current bond amount is? Okay. Does your family have any type of property that is secured at this time? Okay. Are you requesting that the judge lower the bond to give you an opportunity to bond out and whatever stipulations the court may have with a GPS tracker or home confinement, would you be willing to abide by those restrictions? And where would you be residing if you were able to bond out? Okay, and where is that in Beaumont? Okay. And your mom is here today, correct? Okay, and she would be able to let the judge know that that's where you would be residing. Okay, and since you've been incarcerated at the Jefferson County Jail, have you received any write-up? Okay.
Okay, so just for the record, I'm taking judicial notice of the court file. It does include an affidavit of surety surrender. That's where the bond got increased because the bond's been filed. That affidavit, because it reads that the...
Let me break this down in plain English. A surety surrender affidavit is basically a bondsman saying, "We're out. This person is too risky." When that happens, judges almost always respond by raising the bond, because now even professionals don't trust the defendant to comply.
Defendant failed to pay for his GPS device. It had not been charged at that point, so this says since 11/7 of 25, and this was filed November 19th, so it hadn't been charged for a couple of weeks, it looks like. They further stated that he will not respond to their attempt to reach him, and he cannot be located. Therefore, they felt like their bond was at risk, and that's why they filed that affidavit to get off the bond, which was granted, and that's why that was raised. Give me just a second. I also want to take a look at the the probable cause affidavit just so that I can have an idea of what we're talking about, Mr. Hall? Okay, thank you. Any objection for that for this hearing?
No objection.
I'll take a look at it. Give me just a second.
Listen to that description, Wild West shootout in broad daylight. That language isn't accidental. Prosecutors use vivid framing to lock in the judge's mindset before the video even plays. Once the court hears bystander shot, bond reduction chances drop fast. Would you have ruled differently if you were on that bench?
Mr. Coleman, I'm ready.
Partially with the video, some highlighting my 20 shots. He has 9 prior arrests, 2 of which were for unlawfully carrying a weapon. Those cases were pending investigation on him. And just the video, I'll just summarize nothing like a Wild West shootout in broad daylight in the apartment complex. Here's the video. There, you can hit play.
And what about Kendrick O'Field? He's charged as well.
I don't think he got charged.
He was the other shooter, according
He
to
would be
the
person in the video
PC.
here, in the front, saying in front of that red truck. My understanding is it's in here, he's in the background, wearing the dark colored clothing.
Okay.
The bike.
And there it is, motion denied. This is the moment where reality hits. No dramatic speech, no long explanation. Just a decision. In court, silence often speaks louder than words. The system has moved on, even if the defendant hasn't.
And if you're shot, you see her behind like a white vein.
Okay. In that video, it also appears that the first shot, and it's obviously not the best angle, but anyway. The motion's denied. You can go back with the bailiff. This is crazy. Insane. Nope. You need to go back with the bailiff. Good morning, sir. Your Forrest Mabry. And Ms. Holmes, will your client waive the formal reading of the indictment in each case?
Yes, sir.
Give me just. Mr. Mabry, in cause number 25, DCCR 0580. Let's see, are we going up? More
In
than
the first one, because I think
We're getting paragraphs now.
one.
And you're on.
Yeah.
1 and 3? State conceding on paragraphs 1 and 3. Count 1 alleges that you committed the third-degree felony offense of stalking on April 7th of 2025. That indictment alleges that you were previously convicted of, I can't read this, the third-degree felony offense of improper use of equipment from September 27th of 2007. How do you plead to that charge? And is that prior conviction true? And did you enter your plea of guilty and true freely and voluntarily? Okay. Some of the indictments, they stand in like so crazy. No, it's fine. I can print them out and they look fine. I was able to see to get it. All right, sir. In clause number 25, DCCR 1069, you're charged with a state jail felony offense of credit debit card abuse, and that's from March 26, 2025. And then in this case, what are we going on?
The indictment is count 1, 2, and 3.
2 and 3.
Yes, it's 2.
Count 2 alleges that you were previously convicted of improper use of equipment, a third-degree felony, September 27th of 2007. After that was final, you were convicted of possession of methamphetamine in a drug-free zone, a second-degree felony, December 18th of 2009. And how do you plead to that charge? And are those prior convictions true? Did you enter your plea of guilty in that case also, and true, freely and voluntarily, and because you did what they charged you with? In each of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
Okay.
It's admitted. Is there any evidence that Mr. Mabry is not competent?
Oh, yeah.
All right, Mr. Mabry, in each of your cases, I'm going to find that you entered your pleas of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas. In cause number 25 DCCR 0580, find sufficient evidence to find you guilty, and at this time find you guilty of stalking. Find the prior conviction true. Sentence you in accordance with your agreement to a term of 14 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 25 DCCR 1069, also find that you entered your plea of guilty and true, freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 14 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff. Good morning. Are you Deontay Reed? And Ms. Holmes, will your client waive the formal reading of the motion? Mr. Reed, best you can, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Speak up, please. Thank you. You can put your hand down. Mr. Reed, in cause number 24, DCCR 0838, I have a motion to revoke the community super.
This right here is a second chance, and judges don't hand these out often. A 60-day sanction instead of full revocation is the court saying, "We're watching you." Miss this opportunity, and the sentence waiting on paper becomes very real. Do you think probation is mercy or the last warning?